name is Grusic. I am an associate professor here at UCL Laws, and I would like to tell you a few words about conflict of laws, which is a third-year option that we offer to our students. This particular module deals with private law relationships that are somehow connected to more than one jurisdiction. In the module, we are focusing on international contracts, cross-border torts, and cross-border acquisitions and infringements of property rights. The kind of cases that we look at involve, let's say, a contract which is concluded between parties from different jurisdictions to be performed in different countries, maybe breached in a different country. Then we're looking at cross-border torts, which usually occur between parties who come from different places. And similarly, acquisition and infringement of property rights usually occur between parties from different places. Or maybe the object is moved from one country to another, and then different questions concerning international property law arise. The module, in essence, deals with three different questions, and these questions are jurisdiction, choice of law, and recognition and enforcement of judgments. The question of jurisdiction is really the question in which circumstances can one party sue another party in an English court with respect to an international private law relationship. The issue of choice of law is the question whether English law or a foreign law applies to an international contract or an international tort or an international property law issue. And then finally is the question of recognition and enforcement of judgments, which really concerns the issue whether judgments rendered in foreign countries can be given any kind of effect in England. The module is interesting because the law in this area, at the moment at least, is derived from two different sources. On one hand, we have European regulations, and I would say that approximately 2/3 of the law are at the moment derived from different European regulations. And on the other hand, I would say approximately 1/3 of the law is derived from traditional English rules. We envisage that most of the European regulations will be implemented in English law, so even those regulations that are currently part of European law will continue to be applied in this country as part of UK law after the UK leaves the European Union. This means that the module is very useful for those students who want to practice law, because once they learn the rules from European regulations, they will know more or less what are the rules that are applied in Germany or France and in other member states. Whereas the traditional English rules in this area form the basis of the law in other common law jurisdictions such as Singapore, Hong Kong and Australia. So even though the focus of the module is on English law, the things that we study are quite useful for those students who want to practice or advise clients from other jurisdictions. We base our teaching to a large extent on our own research interests, which means that we can offer our students teaching which is based on cutting-edge research. Most of the issues that we cover are of significant practical relevance, so that helps to prepare our students for their future careers.